If you are a green card holder, also known as a lawful permanent resident or LPR, you should know there are several situations where CBP can treat you as seeking admission at the U.S. border. Hi, I'm Regina Cocco, and I'm an immigration attorney and a former visa officer. Making a series of videos to go over these situations for green card holders. So, in the last video, I talked about absences from the US as one situation where CBP can treat you as seeking admission. Here is another situation, and that is if you have left the US while you are in removal proceedings. So, if you're a green card holder, but you've been put into removal proceedings, and you've departed the US during those proceedings without a final decision, or if you're under extradition proceedings and there's been no final decision and no former voluntary departure accepted from you, the government sees this as abandoning your case and self deporting. The consequences of this are if you try to re enter on your green card, even if it hasn't expired, you'll be treated as a new applicant seeking admission from CBP. So, practically speaking, you likely will not be allowed back into the US and you'll trigger a bar for returning to the US. So, the length of the bar can be 5 years, 10 years, or a permanent bar. It depends on a couple of factors specific to your situation. So, I recommend speaking with immigration counsel if you're in this situation. This is, in fact, a serious situation to be in. And I think practically it's unlikely that you would ever be able to regain your LPR status or re enter the US on a visa, even without a permanent bar. There are a couple more situations where green card holders can lawfully be treated as seeking admission than just these two that I've talked about. And I'll go over those in the next videos. As always, if you have questions or seek immigration assistance, please visit my website, coccolaw.com. Thank you.